General termination dates. Under California law, the court-ordered child support ends even if the order does not state when the child turns 18 or up to 19 years of age if the child is still a full-time high school student. The exact California Family Law Code language is as follows. The duty of support by the parents continues as to an unmarried child who has attained the age of 18 years, is a full-time student, and who is not self-supporting until the time the child completes the 12th grade or attains the age of 19 years, whichever occurs first. The two exceptions. The child support obligation can terminate early on two occurrences. One, if the child emancipates, or two, if the child dies prematurely. Emancipation. Emancipation, according to the law, can only be accomplished in three ways. One, the child joins the military and is on active duty with the armed services. Two, the child enters into a valid marriage or domestic partnership. And three, the child receives a declaration of emancipation from the court. Researching graduation date. Finding out when a teenager is going to graduate from high school sounds easy, but for the non-custodial parent who may no longer live in the same city as the child and who is estranged from the custodial parent and the child, finding that information may actually be difficult. Contacting the high school. If the non-custodial parent has joint legal custody, he or she may contact the school that the child is attending directly and obtain the teenager's school records and find out when the teenager is graduating from high school. Stopping the child support order. Normally, there is a court order from the Family Law Court or the Department of Child Support Services, known as DCSS, for child support, and a wage assignment enforcing that support order served on the payer's employer enforcing the child support order. This child support wage assignment will not automatically stop unless the child support wage assignment has a termination date, and often it does not. The reason being is when the child support order is issued and put in place, the court does not know if the child will actually graduate at 18 or 19. Stopping the child support order. The payor, normally the father, will have to file a motion with the family law court that issued the child support order and the follow-on wage assignment, requesting an order terminating the child support order and the wage assignment, and then serving that order on his employer. Support beyond the normal termination dates. Parents may agree to financially support a child longer than legally required. Parents sometimes agree to support their children through college. However, once a parent agrees to support a child longer than is required by law, and it is made an order of the family court, that parent is bound by the agreement, and the agreement can be enforced by the family law court. Support for a disabled adult child. The family law court may order that both parents continue to support a disabled adult child that cannot support himself or herself past the normal termination date for child support under California family law. Takeaways. The normal rule is court-ordered child support ends when the child turns 18 years of age, or 19 if the teenager is a full-time high school student or equivalent.